Welcome everybody. As David mentioned, my name's Sam De Silva. Although I'm the chair of the BCS Law SG, that's obviously a part-time volunteer job. My day job is as a partner, a technology and outsourcing partner at a law firm called CMS Cameron McKinnon Barrow Olswang LLP. It's often been joked that we've got the law firm with the largest name in the world. It probably has. It's a combination of a number of mergers over the years. So what will I be talking about today? So stepping back, I'm going to be looking at really, what is sort of best practice, or what are some tips when, I guess, looking at outsourcing contracts and giving a bit of guidance for project managers. Now, when I've been sort of dealing with these outsourcing contracts, I've sort of seen a number of scenarios. So in one sort of scenario, the project managers are quite, leave it to the lawyers. They're pretty hands-off, and they basically say, you deal with everything, and they don't really get involved. That's one extreme. The other extreme I've seen the project managers think that they're lawyers and pretty much do everything themselves, and get the lawyers like myself to just rubber stamp stuff. So I think those are the extremes, and neither of them are ideal. So I'm hoping that, as a result of this, you'll go down the middle ground, where I think it's going to be a team sort of involvement, a combination of both the lawyers and the project managers working together. Now, clearly an outsourcing contract is a legal document, so I'm not expecting project managers to be, legally qualified or lawyers, but I think you do need to understand some of the concepts so you can make an informed view and actually give the lawyers instructions and actually work with them, rather than thinking this is too complex. And also, I think, sometimes you don't know what you don't know. So it's always good to have a bit of education and sort of understand what the principles are and what the intent of certain provisions are. So in terms of the outline for today, I'm going to sort of set the scene, talk about why it's important to what I refer to as a smart outsourcing contract, then set out sort of best practice framework for an outsourcing contract, then talk about some of the concepts which I think which are troubling sometimes when you're doing these kind of arrangements. So I'm going to talk about post-contract verification, due diligence. Going to look at the scope of services, look at service levels, then talk about limitations and exclusions of liability, their favorite chestnut. Then look at sort of remedies for delay, change control, benchmarking, step-in rights, changes to law, contract renewals, and exit management, and then hopefully have time for questions. So clearly there's a lot to cover there, and obviously I won't be able to go into a whole lot of detail, but hopefully it'll give you enough of a sort of a helicopter view in terms of actually understanding why the importance of some of these provisions and so forth. So I think one of the first things is, it's clear to sort of, I guess, understand what we mean by outsourcing. And I think it means different things in different situations. And why I think this is important is, you may well be doing a deal and it's called an outsourcing when it's not an outsourcing. So it might be a system development project, or it might be a cloud deal, or it might be a system integration project, or software licensing. The inverse is true also. You may be thinking that you're doing a software licensing deal or a system development deal when it's actually an outsourcing. So I think just because the team or the project name is called outsourcing, I think you need to step behind that and actually understand, what is the actual underlying nature of the arrangement. So as I said, the outsourcing could mean subcontracting arrangements to contracting relationship to outsourcing partnerships. Now, a typical definition is, as set out in the slide, effectively it's transferring the responsibility for a specific business function from an employee group to a non-employee group, which may or may not include the transfer of assets such as personnel. So it's not just IT outsourcing, it could be any BPO or business process outsourcing, whether it's waste management, it could be security services, it could be finance and accounting. So it's a business function or a process which is basically being transferred to a third party, and that's what the basic nature of an outsourcing is. So why is it important to what I sort of refer to as a smart outsourcing contract? So case studies and research have indicated that a poorly drafted contract can hinder the success of an outsourcing project. That's not to say if you spend, lots of money with lawyers like myself, you'll get a perfect outsourcing contract and there'll be no problems. But the research indicates that having a strong, robust contract will manage risk and will prevent problems further down the line. So, it is having that mechanism in place, and it's basically getting the framework in place to ensure that you manage those problems and issues. The other things which you need to bear in mind is if you're using a contract drafted by a service provider, it's not going to be a level playing field. So the service providers do outsourcings day in, day out, whereas you as a customer may only do an outsourcing, once every 2 or 3 years. So the service provider's contract are obviously drafted in their favor. They would have spent a lot of money with lawyers and drafting a contract which manages their risk and is basically, in their favor and sort of tries to transfer the risk to the customer. So if you're starting off with that contract, it's not a level playing field. So you're starting off with a disadvantage. Now, I always advise customer clients who are doing outsourcing is try to get your contract. Sometimes that's not possible if you don't have the negotiating leverage, but it's always better to start off with your contract. And when you start off with your contract, what you need to make sure is it's a balanced contract. So there's no point putting forward a contract to a service provider which is so one-sided that effectively just protects the customer's interest and passes all the risk to the service provider or supply. It needs to be balanced and the risk needs to be allocated appropriately. Otherwise, if it's a one-sided contract, suppliers will either price for that risk, so you won't get the most competitive price, or they may simply decide not to bid for the work. So you have a smaller number of service providers or potential bidders who want that work. So yeah, the takeaway is, regardless of the contract you're using, it needs to be balanced and fair. Obviously, it needs to protect your own interest, whether you're a customer or service provider, but there's no point providing something which is so one-sided. So in terms of a framework for a typical outsourcing contract, you'll be glad to hear I'm not going to go through every clause of an outsourcing contract clause by clause. We'll be here all night, but I'm going to talk about principles. So in terms of the framework, what does an outsourcing contract need to sort of set out? So it needs to set out the roles and responsibilities. So it needs to set out the roles and responsibilities of both the customer and the service provider. So an outsourcing contract, it's a relationship-based contract. It's for a long term. So it's not like a typical supply contract where you got the master and servant relationship. So there's obviously two parties, could be multitude of parties, but each of those parties will have roles and responsibilities. So you need to set those out in the contract. The other thing you need to remember is outsourcing. I'm going to sound like a management consultant here. Sorry for those management consultants in the audience. Outsourcing is a journey. Yes, it is a journey. So the contract needs to reflect what the cycle of outsourcing is. So effectively, it needs to reflect. So let's take, for example, a first generation outsourcing, i.e. where the customer hasn't done an outsourcing before. So it's been doing the services itself. So effectively, there'll be a transition to the service provider, then there'll be a steady state, and then there'll be disengagement either back to itself, i.e. it's providing service itself, or to a new service provider. That's one scenario. That's first generation outsourcing. But if it's a second or third generation outsourcing, that's where the customer's already outsourced to a service provider. What the contract needs to reflect is the services will go from the incumbent service provider to the new service provider, then a steady state, then disengagement, either back to itself as a customer or to a new service provider. So the contract needs to reflect what's actually happening in practice. The contract also needs to set out the risk and reward. So, there's no point having a contract which is all about, sticks or penalties. There also needs to be incentives and rewards for the service provider. So if it's sort of performed, in expectation of service levels, is there additional remuneration it receives or compensation it receives as a bonus? If it sort of accelerates delivery, or if it makes cost savings, is there some kind of sharing of the cost savings? So you need to think about it in both risk and rewards way, rather than just looking at it and basically, look, if the service provider doesn't perform, we're going to penalize or basically whack it over the head with a stick. It needs to think about, well, what about if it does a really good job? How is it incentivized to do a good job, and what is the remuneration and compensation it receives? Now, expectations. So expectations is really about expectation levels is really about service levels. So this is really about the services, the actual achievement of various services. So let's say if it's an IT outsourcing, what is the response time? If it's some kind of business process outsourcing, for example, credit collections outsourcing, what is the sort of the processing time for collecting that debt? So what are the actual, the agreed parameters for that particular service? The next thing the outsourcing contract needs to set out is, what are the mechanics for policing the relationship? So this is all about governance. And one thing I have sort of seen from my experience of doing hundreds of these kind of contracts is, this needs to be quite bespoke. Often I see customers and service providers just using a governance schedule that they used in a previous deal and putting it in the current deal. It needs to be quite bespoke, and a bit of care and attention needs to be taken in making sure that's right. The other thing I would say about governance schedules, keep it simple. I've seen governance schedules which go in for like 10, 15 pages with a lot of diagrams, arrows here, lots of steering committees, lots of other sort of various escalation routes and stuff. All looks good on paper, looks pretty robust, but will that actually work in practice for the relationship? Is it something practical, and is something actually workable? So you need to make sure it actually reflects what's happening on the ground, and that's why it needs to be bespoke rather than something which is cut and paste from a previous deal. So post-contract verification due diligence. So what is this? So this is effectively the process where you've got to, you're entering into an outsourcing contract, and the service provider hasn't had the time to do the due diligence on your business or the operations or the service levels. So it hasn't really had the time to sort of get under the skin and see what it's getting into. So effectively what it says to the customer is, look, we haven't had the time, but we're prepared to contract on the basis that we have this post-contract verification or due diligence period, post-contract signature, where we will do the due diligence. And, effectively, as a result, over that period of time, they do the due diligence, and then, if they find certain things, the pricing may be adjusted, service levels may be adjusted. Now, why is this concept being introduced? So the rationale is the timetable. Sometimes there's not enough time for the contracts done for the service provider to do that before contract signature. Sometimes it's overconfidence by the customers. The customer thinks, oh, look, there's not going to be any skeletons in the closet. We're happy with having this process. Service provider's not going to find anything post-contract signature. Sometimes it's the talked into the golf course deal. So it's the CEO of the service provider and the CEO of the the customer who, well, might not be during COVID times, but pre-COVID times at a golf course or a dinner, and the service provider says, look, effectively, this is our standard position. We're never going to enforce it. We'll just have it as a matter of practice, and the customer just gets talked into it. Now, the question often I get asked by my clients who are the customers, say, is it a good thing? I would probably say 99.99% of the time is no, it's not a good thing. Now, the problem is, how can you justify not having it if you don't give the service provider enough time to do the due diligence beforehand? So if the service provider's got time to do it beforehand, obviously this falls away. But if they haven't, I think you as a customer has a very difficult time to justify not having it. So if the timetable, if that extra time can't be built into the timetable prior to contract signature, what is the best practice approach? Well, you need to put parameters around this sort of post-contract verification phase. So it needs to be, 6 months, 9 months, whatever, but it needs to be an agreed time. Also, you need to know what's actually being evaluated. What are they actually looking at? And the most important thing is right at the end, what happens if certain assumptions don't hold true? Is it a pricing adjustment? Is it a service level adjustment? And then you may want to put sort of, caps or parameters around that. So you may want to say, well, regardless of what you find as part of the due diligence process, the pricing can't get increased by more than 5% or X percentage, or service levels can't be reduced. So at least you've got a cap or threshold that that it won't be exceeded. Otherwise, it's an open-ended checkbook. So, the service providers ideally want a post-contract verification with no parameters. And effectively, the contract signed. At the end of the post-contract verification period, what they say is, look, all of these assumptions that we made don't hold true, so we need to adjust the pricing by 15%, 20%. You've already sort of signed the deal. Very hard for you to get out of the deal, so you're basically tied into that deal. So that's what the situation is, what you want to avoid. So scope of the service and service requirements. So what's this all about? So this is about the functions which are included. So what are the services which are actually being carried out by the service provider? It seems a bit trite. Yeah, of course, that'll be documented, but I've seen many service descriptions which this isn't documented clearly, as well as the functions and processes which are included. What's actually excluded? So for certain things that the service provider isn't doing, it's better to actually set out expressly it's excluded. Otherwise, it gets a bit of a gray area. You also need to think about dependent services. So if a service provider needs to do a service and it's dependent on services that you need to do, that you are doing, or a third party is doing, what are those dependent services, and what happens if those dependent services aren't actually performed? What happens in terms of liability, responsibility, excuses, relief, and all that. Assumptions. So assumptions is effectively, what are the sort of the parameters that the service provider has based the contract, mainly the pricing on? So it's a number of users, it's a number of processes, a number of sites, all those assumptions need to be set out. Obviously, from a service provider perspective, they will want to have as many assumptions as possible. From a customer perspective, what you need to do is actually narrow down those assumptions. So you don't want a whole raft of assumptions, because it's effectively a bit of a get out or relief for the service provider to adjust pricing. So you need to review those assumptions really carefully and make sure it's a narrow list and you validate them. The other important thing about assumptions is effectively to know what happens when those assumptions don't hold true. So I've seen lots of contracts where there's a whole raft of assumptions, but it's not very clear at all what happens when those assumptions don't hold true. A simple example may be, the outsourcing is based on, 1,000 users, the IT outsourcing. Yeah. Okay. What happens if there's, 1,005 users or 1,500 users. What is the adjustment to pricing level? What is the adjustment to service levels? So you need to, for each assumption, you need to have sort of different bandings and parameters in terms of what happens if those assumptions don't hold true. Otherwise, it's, as I said, it's previously on the post-contract verification concept. It's a bit of an open-ended checkbook. The other thing is, should the requirements be input-based or output-based requirements? Now, what I mean by this is input-based requirements is more prescriptive, whereas output-based requirements are more outcomes-based. So I'll give you a simple example. So let's talk about an outsourcing of security, not IT security, but physical security. Yeah. So an input-based requirements would say, the service provider will use, 5 security guards who will come in and, walk around the premises. There might be security guards, security dogs, and so forth, and they will do it. They will do a visit once every 3 hours or whatever. It might be more during sort of the night time. So that's input based. That is very prescriptive. Output based requirements are more focused on the outcome. So an output based requirement for that sort of outsourcing for security would say the service provider will ensure that there are only one break-in once a year, for example, or no more than one break-in once a year. So in that output-based requirements, you're not so concerned about, how the service provider does it. So they may use 1, 2, 3 security guards, or no security guards. They may use drones, for example, or some other technology or CCTV. So you're not so concerned about how they do it, but you're more concerned about the outcome. So the question is, should service requirements be input-based or output-based? Now, in most cases, I would recommend they're output-based, so they're outcomes-based. But there may be certain services you, as a customer, want to be quite prescriptive. You want to be quite sort of, I guess, directive in terms of the service provider. So the most common one is security requirements. So often in security requirements, customers say, you need to use this kind of encryption technology. You need to adopt this kind of various mechanisms and so forth. So there may well be certain services that you want to be input-based, but my recommendation is most services should be output-based. You should only be focused on the outcome, and you leave it to the service provider as the experts to actually deliver to that outcome. The service levels. So why are these important? Well, this is basically the crux of the outsourcing contract. Obviously, you have your legal T's and C's, which talk about risk allocation and liability and IP and all that, which is important. But service levels are paramount. So this is the quality of the services you're getting. So it's really important to get this right. So things you need to think about service levels is, it's all well and good having service levels documented, but can you measure service levels? So I've seen outsourcing contract where it looks really good, the service levels, and I ask my client, oh, that looks good. How are you going to measure that? And they go, yeah, we don't know. Ask the service provider and they say, we don't know. So there's no point putting service levels which can't be measured. They need to be measured. Obviously, there needs to be an obligation on the service provider to report on those service levels. Otherwise, you don't know whether they're being achieved or not. Now, in terms of outsourcing contracts, how do you establish service levels? So there's 4 key ways to establish service levels. The first way is the customer's own operation. So if the customer was doing say it's an IT outsourcing, was doing the help desk themselves, it would be their own internal service levels. The second way is to use service providers' own standards. So, they may have platinum, gold, bronze, different service levels. So that could be something that you use. Then it could be market standards. So certain services have market standards. For example, ITIL have various service levels for support desks, and there's other market standards. And then the fourth way is basically post-handover measurement. So this is basically, you have a post-contract verification period. So effectively, you have service levels during the first 6 months, 9 months after contract signature, and those are the service levels which are established for the rest of the contract. Now, my recommendation is to avoid the first and fourth bullet points, because in terms of setting the service levels in terms of your own service levels, your internal service levels, they may not be very good. I mean, presumably that's one of the reasons why you're outsourcing. You want improved service levels. So setting the benchmark as your own one is probably not the way to go. And then in terms of the fourth bullet point, again, if you establish the service levels based on this post-handover measurement, no service provider, no matter what they say, they're not going to really be delivering to high service levels or exceeding service levels when they know that's what they're going to be measured on during the rest of the contract. So, the recommendation is use either, the service provider's own standards or market standards when you're setting service levels. Excuse me. So limitations and exclusions of liability. I find this bit of an iPhone moment. So whenever this topic comes up, everybody in the room, including sometimes the project managers and the commercial people, start looking at their iPhone, thinking that the lawyers can answer this question. Obviously, we can advise on this, but this is really a business operational commercial issue as well as being a liability issue. So as well as being a legal issue. So I think the two key questions when you're looking at limitations and exclusions of liability clauses, and these can go on for many pages, is, the two key questions are, what categories of loss can be recovered under each head of loss and how much can be recovered. Now, if your liability clause can't answer those two key questions, you've got a lot of work to do. If they can, you're probably about 85–90% of the way there. Now, in terms of a framework for a best practice liability clause, how does it need to be sort of set out or drafted, or what concepts need to be covered? Well, first, there's the losses which can't be excluded by law. So these are basically death or personal death caused by personal injury, death or personal injury caused by negligence, that can't be excluded. The second one is fraudulent misrepresentation, that can't be excluded by law. And the third one, which not many people know about, is effectively the implied warranties under the supply of services and goods acts in terms of service performance and so forth, and title. So that can't be excluded by law. So if you're dealing with a service provider who's trying to exclude all types of liability, even the ones which can't be excluded by law, either the service provider doesn't know the law or they do know the law and trying to circumvent it. I don't know which option is better, probably neither. So you may want to reconsider doing a deal with that service provider. Now, in terms of the general financial cap, so this is effectively when things all go horribly wrong, what is the maximum amount you can sue the service provider for? Now, unfortunately, a bit of an unsophisticated approach is sort of developed for this. So usually it's basically a finger in the air and usually linked to the charges. So, 100% of the charges, 150% of the annual charges. Now, I think that's quite an unsophisticated approach and doesn't actually reflect the nature of risk. So what I've been seeing in recent years is this concept of liability phases. So during during an outsourcing contract, there's three phases. Yeah, first phase is, basically transition in. Second phase is business as usual, and third phase is disengagement or transition out. So what I've seen is different liability caps for those different phases. So it looks a bit like a step chart. So at the first phase, the liability cap is higher because it's more likely problems will occur. During the sort of the business as usual, the liability phase is lower because, the services are up and running. Hopefully all the problems have been ironed out. And then in the disengagement phase, again, the liability is increased because if the service provider hasn't been, I guess, appointed for the new contract, it's probably lost its incentive to perform because it knows it's getting kicked out and a new service provider is coming in. So having those liability phases sort of matches the risk of the project rather than a general financial liability cap, which is effectively a straight line during the term of the contract. Now, the Now, the other things you need to think about is thinking about different financial caps for different categories of loss. So for example, damage to property, you want a higher liability cap than the general cap. Often that is linked to the value of the property, i.e. the physical property. Breaches of confidentiality and IPR indemnities, you often see as a customer, what you should ask for is unlimited liability, because these breaches of these aren't failures, aren't service failures. They're more sort of failures of contractual obligations. So, you know, most service providers accept unlimited liability for confidentiality and IPR indemnities. If they don't, you probably need to revisit that and ask them why they're not sort of inconsistent with market practice. There may be other categories of loss. For example, if it's an outsourcing service dealing with payment services, you may want an unlimited indemnity in terms of PCI DSS breaches, for example. The other thing we've been seeing in recent years, particularly since sort of the GDPR, since 2018, is having a separate cap for liability breaches and liability for data breaches and regulatory fines. Now, before the GDPR, most service providers were happy to take unlimited liability for data protection breaches because, you know, the fines were, you know, half 500K. But given the GDPR, as we know, the fines are fairly significant, the regulatory fines, and so therefore the service providers are more resistant to giving an unlimited liability. And what they're seeking is sometimes they try to cap it to the general cap. I would always recommend from a customer perspective to have a cap higher than the general cap, so have a super cap effectively. So what I mean by a super cap is, you know, say the general liability cap is £1 million, the super cap might be 5 million or 10 million, i.e. a cap higher than the general cap. The other thing you need to think about is the customer's liability service provider. So this is sometimes a difficult thing to pick up because often if you're not a lawyer, if you're looking at a contract, you're only looking at the words on a page, yeah? But in terms of concepts of the customer's liability service provider, if there's nothing talking about the customer's liability service provider, it means that the customer's liability service provider is unlimited. Now, the problem is it's very hard if you're a non-lawyer to pick that up because that won't be actually written down. It'll be just missing. So the thing is, you don't know what's missing unless you're, you know, quite familiar with these liability concepts. So, you know, if it's missing unlimited liability, you may think, okay, well, our only liability is to pay the service provider, so we'll accept that. My view is in an outsourcing arrangement, you know, you've got more, a customer has more obligations than just paying. They may have certain responsibilities, and if they don't perform those responsibilities, the service provider has the ability to claim compensation or relief from the customer. So it's important for the customer to cap its liability as well. Indirect or consequential losses. So this is where effectively, you know, you've got a clause saying service provider isn't liable for indirect or consequential losses or loss of profit, loss of income, whatever. Quite a wide sort of wording there. So indirect and consequential losses are sort of losses which is one step removed. Now, I'll give you a bit, and direct losses is sort of losses which flow from the breach. So I'll try to give you an example. So let's say you're doing an outsourcing, and you know the outsourcing provider doesn't perform. So your indirect losses would be, your direct losses would be effectively the charges you paid for the service provider. You paid the charges to the service provider, they didn't perform, so you know that is the loss you suffered. An indirect or consequential loss could arguably be the wasted management time, the costs of getting another service provider on board, you know, maybe lost sales because the outsourcing hasn't been done. So they are losses which sort of don't flow directly from the breach, but one step removed. Now, the point of all this is, unfortunately, the meaning of indirect or consequential losses isn't very clear. In some cases, you know, certain things are excluded, in some cases they're covered. So the takeaway from this is, and my recommendation to clients is, if there's certain losses you want to make sure that you want to recover from the service provider, for example, regulatory fines, or maybe anticipated cost savings, or loss of business, you deem them to be a direct loss, so they're not inadvertently excluded by the exclusion. So you would sort of have wording which effectively says these losses are deemed to be direct losses, and you list those losses. Obviously your lawyer can help you with the drafting, but that is the concept, having a concept of direct losses, deemed direct losses. So limitation, exclusions, or liability, the devil is in the detail. So there's two examples here of typical sort of exclusions and liability. So you may think it looks similar. Well, it does look similar. But the example 2 is actually narrower. And the reason why it's narrower is because of that word including. So you see the service provider excludes indirect losses, consequential losses, including loss of profit, loss of revenue. So example 2, because of that word including, it's only indirect loss of profit or indirect loss of revenue, indirect loss of business, which has been excluded. So much narrower. So example 2 is better for a customer, whereas example 1 is much broader. Given that there's no word including before loss of profit, loss of revenue, courts have interpreted that both direct and indirect loss of profit, direct and indirect loss of revenue have been excluded. So example 1's broader. So you can see that just that word including has quite a significant impact. So as I said, the devil is in the detail. And that's just one example where, a missing word or a word in a certain place could have a fairly significant ramification on the actual risk allocation position. I'm raising the next point just for the sake of completeness. So Unfair Contracts Terms Act 1977, or UCTA, what that basically says, if there's two parties of sort of, I guess, equal bargaining power, if they enter into a contract which hasn't been negotiated, then if their clause is held to be sort of unreasonable, it'll be unenforceable. So sometimes customers take the view, okay, we'll sign the supplier standard T's and C's, we won't negotiate. The liability clause is so unreasonable, they'll be unenforceable. I think that's quite a dangerous sort of proposition or dangerous approach, because you're basically, what you're doing is you're relying on a judge on a certain date to make a view that a certain clause is unenforceable. So my view is always negotiate the limitations, exclusions, or liability clauses, and make sure you get the best position you want, rather than relying on UCTA as something that will save you, because you haven't spent that time or effort in actually trying to negotiate these clauses. So remedies for delay. So this is when the actual service provider isn't actually delivering in terms of the project timetable. Obviously, as project managers, this will never happen, because you'll make sure that they do. But if they don't, what happens? So the concept is effectively this concept of liquidated damages. So every week or day of delay, a certain amount is paid as compensation. Now, the general rule about liquidated damages is there need to be a genuine pre-estimate of the loss, because if they're not, they're held to be a penalty and therefore unenforceable. So if it's a penalty, if it's more than the losses you'll likely suffer, the court will basically say, no, that's a penalty, you can't recover that. So what that means is that when you do these liquidated damages calculations, you need to make sure that the number that you put in the contract actually bears some resemblance to the loss that you're likely to suffer. That's not intended to say that you need to be 100% accurate, but what the courts and judges have said is there needs to be some kind of working out or some kind of working paper that you can demonstrate that before you came up with the figure in the contract, you've actually turned your mind to it, and you've actually sort of tried to assess what the loss is. Because if you don't have that, it's most likely the judge will say, the service provider will argue, well, that's a penalty and unenforceable. So you need to have your workings before you come up with the number. Now, often what I see is, in terms of liquidated damages, is the customer will go with a high number, say £10,000 for each week of of delay, service provider goes, oh, too much, £5,000. Okay, we'll split the difference, 7,500 for each week of delay. Now, if you don't have any workings or anything, again, I think that is quite a dangerous approach. So, you know, the takeaway is to have that workings in terms of knowing what those losses are likely to do. Again, it doesn't need to be 100% accurate, but it needs to bear some resemblance to what's going to happen in practice. The other thing with liquidated damages is if service providers sort of propose this and it's accepted by them, they often say liquidated damages are the sole and exclusive remedy. Now, that's a very dangerous position for a customer to accept or agree to. The reason being is if it's a sole and exclusive remedy, it means you can't terminate the contract and or you can't sue for damages at large. So basically all you're getting is liquidated damages. So I think that is quite a dangerous position. So from a customer perspective, you need to resist that position. There's a couple of fallback positions. One position could be you saying it's a sole and exclusive financial remedy. So you're basically giving up your right to sue for damages at large, but you still got the right to terminate. Or you could introduce this concept of a liquidated damages cap. So what you say is it's a sole and exclusive remedy up to a liquidated damages cap of, say, 500,000 or whatever the figure is. Until that figure is reached, liquidated damages is your sole remedy. But after it's reached, then all bets are off, and then you can either terminate or you can sue for damages at large. The other thing you want to make sure is that how the liquidated damages, their relationship with the liability cap. So we talked about liability cap in an earlier sort of slide. So, you know, how does the liquidated damages eat into the cap or is outside the cap? Because I've been in situations where effectively service provider and the customer had an arrangement. It's been a long-term thing. They were quite late in delivering, and there was a lot of liquidated damages. And then they got the services up and running, but then there was a problem, and the customer wanted to sue the service provider. But when we looked at it, basically the liquidated damages had eaten into the liability cap. So although the customer could argue that there was a breach of contract claim, the liability cap was zero because the liquidated damages are eaten into it. So you need to make sure what the relationship is, i.e. is the liquidated damages a part of the liability cap, or does it fall outside the cap, and is there a separate cap? So there is an interplay you need to consider. How are we doing for time? Okay, change control. So outsourcing contracts, as you know, are long-term relationships, so change will happen. You won't believe how many outsourcing contracts I've spent, 6 months, 9 months helping a client sort of negotiate and draft. We sign it. The next day, we get a change control request from the customer or the service provider. So change will happen. So what are the key features you need to think about in change control? So first thing is, what is the impact on pricing? So certain changes, you can price for them. And often in IT sort of outsourcing contracts, you have these things called MACs, moves, adds, and changes. So it's basically a menu, sort of type of mechanism where certain aspects are priced for differently. So, if you add a user or if you do a certain move, this is the pricing. There may be other things which you can't price for, therefore you need to know what the hourly rates are or the day rate. So you need a bit of transparency in terms of what happens if there's a change. So another thing in terms of change control, you need a requirement for sort of notification or impact assessment. The requirement for notification is more if the change is coming from the service provider. So if the service provider is doing a change, you need an obligation on them to actually tell you. In terms of the impact assessment, that's probably most relevant if the change is coming from the service provider or it's coming from you to the service provider. So the impact assessment is effectively saying, well, if you do this change, the impact on the pricing, the impact on the service levels, the impact on, delivery timetables will be this. So that will allow you to make an informed decision. So you as a customer may think, well, we need to do this change, but without that impact assessment, you don't actually know what the impact of that change is. So it is a very important thing to have that obligation that the service provider does that impact assessment. The other thing with change control is flexibility. So, change control processes can be quite rigorous and a lot of process around it, and sometimes it needs to be, because these changes could have a lot of impact. But there may be certain changes where you don't want that robust sort of process, and you want to do that in an agile manner, and that needs to be done more quickly. So you may want to think about having 2 change control processes. So effectively the standard change control process for pretty much all the sort of the changes which you need to have that robustness built into, but you may want a fast track change control process where effectively if a change is of minor nature, you don't have to go through the whole process. There still is a process, but it's more fast tracked and short form. So that's also something you need to consider in terms of change control processes. The other thing you need to think about is, what about changes that don't attract charges? i.e., this is where you don't want, basically change control is an ability for a service provider to arguably, increase pricing or get more revenue. So you may want to agree up front that regardless of what the change is, there are certain things which won't attract additional charges. So you may want to say, minor technological changes. You may want to say changes which have already been baked in. You may want to say changes in law, and we'll talk about changes in law in a few slides. And then continuous improvement. So if the service provider has an obligation to continually improve the services, and that's part of the services, part of the charges, you don't want them to actually come up with an idea that they actually charge for. So things that you need to think about. Sorry, hopefully I don't lose my voice before the end of the presentation. So a change control process is really an agreement to agree. And, hopefully most of you know that an agreement to agree is an unenforceable obligation. So in a contract, if you have the parties will agree to do something, that's fairly meaningless because you can't force any party to actually agree. So change control procedure by the nature is an agreement to agree. So both parties need to agree to it. But there may be certain scenarios where you want the service provider to implement the changes, i.e., it's not an agreement to agree. So the most common scenarios is if it's a regulatory requirement or change in law. So you effectively say, look, there's a change in law, you need to implement this change so the services still comply, and you don't want the service provider to say no. The other scenario which I've seen is if it's related to do with security. So there may be a security vulnerability or an issue that the service provider needs to address. Again, you don't want to be in the situation where you request that change, the service provider says no. You want to basically force the service provider to do that. Having those kind of provisions, the service provider will want to have a get out. So the most common get out is the service provider will say, well, you've got to basically pay for that change if you're forced to do it, which I think is a reasonable request. The other get out is often the service provider says, well, if it's totally outside our scope of expertise, again, you can't force us to do it. Again, that's, I think that's a reasonable response from the service provider. The next point, rationalizing or reinstatement of the new baseline contract. So this is really a practical tip. So as I said, often these outsourcing contracts get changed. In a 5-year contract, there may be 10, 15, 20, sometimes 100 change control notes. So the problem with having those number of change control notes is very difficult to see what the actual agreement looks like. So you may have a change control note that says it amends this clause 10, and then you have a second change control note that amends the amended clause 10, and then a third one which amends the amended clause. So you sort of get my drift. So you've got the change control notes and you've got the baseline contract, the original contract, but it's very difficult to actually put them together to actually see what the actual rationalized contract is. So a practical tip is basically place an obligation on the service provider saying every 3 months, 6 months, whatever, you will rationalize and reinstate the contract. So you'll incorporate all the change control notes in the contract. So, at that time we have got a contract which incorporates all the change control notes. So we only need to look at that contract and not all the change control notes. Yeah. excuse me. So benchmarking. So this is the concept basically where you compare like for like to ensure that the deal continues to match what the market can offer. So it's quite a useful mechanism protection for the customer. So the key issues is the approach to benchmarking. So there's two approaches to benchmarking I've seen. The first approach is effectively you go to the service provider and say, service provider, we want to make sure that the services you provide to us, the pricing you give to us, you don't give any better pricing to any other customer of yours. So that's more an internal sort of benchmarking. The other approach is effectively you go to the service provider and say, we want to make sure that, you know, that the services we get from you, the pricing we get for you for those services, we can't go to another supplier or service provider and get the same services for a lower price. So that's more external facing. So in terms of looking at the benchmarking provision, you need to consider which approach, and there's no right and wrong answer, but it needs to be clear what approach to benchmarking you're taking. And the other issues is, you know, how often is the benchmarking done? Often benchmarking can be quite a time-consuming process. So I think having benchmarking more than once every 18 months or 24 months is not unrealistic. So if you want benchmarking every 12 months, I think you're asking for something quite not very practical. Often the service providers will say there's a moratorium on benchmarking, i.e. for the first 24 months, there's no benchmarking. Again, I think, you know, you need to sort of negotiate that, but I can see their sort of argument. They're saying, well, you've done a procurement process, you know, you should be comfortable that the pricing that you've got is pretty good, and it's only after 24 months that you need to do the benchmarking. I guess if you're resisting that and you want to do benchmarking any quicker, I think the procurement process hasn't probably run as smoothly as possible, and you haven't got confidence that you've got the best pricing. By whom? So who is doing the benchmarking? Now, often you would need to engage a third party to do the benchmarking because they'll have the data sets. You as a customer won't have the data set, so you need to ensure that the provisions allow a third party to do the benchmarking. What is being compared? So there's usually two things which are being benchmarked, usually pricing and service levels, so that needs to be clear. Normalization. So this is the process where effectively you take out all the sort of deal specific things of the arrangement. So often a service provider's argument for saying we're not doing benchmarking is, you know, our services we provide are so unique, there's no comparators out there, you can't compare us. Yeah, I think most services, there are certain aspects that can be compared. So normalization is basically the process of taking out those deal specific or unique things out of the equation and just sort of comparing those things which can be compared. So that process of normalization needs to be built in. Next point, this is probably the most important thing there in a benchmarking schedule. You know, what happens if there's an adverse result? So what I mean by adverse result is, you know, let's say you're doing an outsourcing and the price for transaction is, you know, £10 a transaction. You know, an adverse result is if you do the benchmarking, you find out you can get the same transaction done by £5. Yeah, so that's the adverse result. So what happens if there's an adverse result? Now, I've seen benchmarking schedules that go on for 10, 15 pages. Then right at the end, it says, you know, as a result of the benchmarking, if there's an adverse result, the parties will engage in good faith negotiations. Now, remember what I said about agreement to agree, that's not enforceable. So that is a pretty toothless sort of kind of obligation. So, you know, I would argue there's no point even having a benchmarking schedule if that is the outcome. So what you want to make sure is that there's an enforceable obligation, i.e. if there's an adverse result, the service provider must adjust the pricing to match the benchmark result, or you have a right to terminate. Now, service providers obviously will resist this because they don't want this automatic price adjustment. So a concept that's been introduced in terms of a sort of a permitted variance or deadband. So this is effectively where you share the risk. So let's say the dead band is, let's say, 10%. Yeah. So let's say it's £100 a transaction. The dead band is 10%. So if you find the transaction is, £90 a transaction, then basically there's no adjustment. If it's more than that, i.e. more than the dead band, then there's a price adjustment. So as you can see, you're sharing the risk, and that gives a bit more comfort to the service provider. The other thing you need to think about is benchmarking. Who carries the cost of benchmarking? Now, often the costs are shared, but you as a customer may want to say, well, if we do the benchmarking and we find out there's an adverse result, you will reimburse our costs. If you argue that, the service provider will say, yeah, okay, we accept that, but also the corollary is true. If there's not an adverse result, you, customer, have to carry the service provider's cost. So it cuts both ways. So step-in rights. So these are often seen, as you probably know, in public sector contracts. It's effectively to avoid the sort of nuclear option of contract termination. So effectively, the service provider is not sort of delivering the service. Instead of sort of, terminating, you have the option to either step in or get a service provider step in. So I think probably the most public sort of example of this is during the Olympics, when London was hosting Olympics, and GS4 wasn't able to do their service they provide, and the army stepped in. Again, there was an example, I think again it was a GS4 where they couldn't do the sort of the prisons, the service in the prison, again that the army had to step in. So that's an example of step in rights. So the key issues is what is the trigger for the step in? Is it a breach? Is it a material breach? Is it an emergency event? Is it a force majeure event? How long does this step in last for? Is it for a certain period? Is it for until the services are reperformed? What happens during the fees for the step in period? So you don't want to be in a situation where you're paying the service provider for the services, they're not performing, you're still paying them, you got another service provider stepping in, you're paying that service provider. So you want some kind of rebate or adjustment to the pricing. What happens if something goes wrong during a step-in period? Who's responsible, liable? Often you won't be able to step in yourself. You would have, outsourced it because you haven't got the know-how. So you often need the third-party support for the step-in. So what that means is that you'll need cooperation of the service provider for that. So you need to build that into the step-in provision. So service providers don't like step-in rights for obvious reasons, and they will try to push back on it. So how can you sort of make it more palatable to the customer? So what you want to make sure, some of the options to consider is saying, okay, we have a right to step in, but it's only services affected by the trigger event. So all the other services, you continue to perform them, that's fine. We're only stepping into this particular service. You may also want to put an obligation that you're not managing the service provider's personnel or using the service provider's systems. Sometimes service providers say, well, you can step in, but you can't use a competitor of ours. The problem with this is how you define competitors. Now, service providers will define competitors to include every sort of Tom, Dick, and Harriet. You obviously want to make that list as narrow as possible, so you're not precluded from engaging a third party. What happens to the service levels of affected services? Now, obviously, if you're stepping in, the services aren't being performed, so effectively service credits may be payable. But I think asking for service credits and step in is basically like a double whammy for the service provider. So what you need to acknowledge is, okay, if we step in, we're sort of acknowledging we won't sort of levy service credits. Payment, as I said, you want to make sure that you're still paying for the services that are not being stepped in. It's only the service that you're stepping in that you get adjustment to the pricing. Step out triggers. Often service providers want to know, well, okay, if you step in, when are you going to step out? When is this all going to end? So you need to set out what the step out triggers are. Is it when the service provider can justify that it can perform the services? Is it when the event that led to the step in is ended, or that kind of thing needs to be documented? The service provider may want an obligation on you to act reasonably and mitigate losses. I think that is an obligation at law, so you're not actually offering anything. So I think you should just accept that, because even if you don't have that wording in there, you probably have an implied obligation to do that. As I said, that's not an additional obligation. Additional obligation is if the service provider says, we want you to the customer to indemnify us against any losses. Again, like any indemnity, you need to make sure whether you're prepared to give that indemnity, what the scope of the indemnity is it limited, is it capped, and so forth. So before giving any indemnity, you need to go through that thinking process. Changes in law. So this is effectively, what happens if there's a change in law? Who bears the cost? So I think when you're looking at this, again, sometimes an unsophisticated sort of approach has sort of developed for this. The more sophisticated outsourcing contracts sort of deal with it in a much better way. So I think you need to think about the different categories of law. So there's the general laws. So these are the laws which apply to both the service provider and the customer. And I think each party bears its own sort of costs in changes to that. Then there's sort of customer specific laws. So these are laws which apply just to the customer. So it may be a financial institution where it's subject to various FCA rules. So let's say, for example, you're doing an outsourcing and there's a change to those laws. Who bears the cost? Is it the service provider or is it the customer? Now, I think it depends. I know it sounds like a typical lawyer there. I think it depends on what kind of service provider it is. So if it's a service provider providing particular services to that sector, I think you've got a good argument to say, look, this is a cost of you doing business. We've engaged you because you're an expert in this particular sector, so you need to comply with those laws and pay the cost. However, if it's a general service provider, so it might be a general IT outsourcing service provider who's got customers across a wide variety of sectors, in that situation, it's quite difficult for the customer to say, hang on, you're providing services to us, we're regulated. If there's a change in our law, you need to bear the cost, because the service provider goes, oh, hang on, we're not the regulated entity, you are. So again, as I said, it depends on what kind of service provider it is. Service provider specific laws. So these are laws which apply to the service provider because of the nature of the business they're doing. Any changes in law, the service provider should bear the cost too. So in terms of contract renewals and exit management, now often outsourcing contracts, this is not considered, it's a bit like a marriage really, you don't want to really think about sort of divorce, and you don't want to think about, exit management or contract renewals because, often it's 10 years down the track. But it is something you need to sort of set out at the outset and make sure your contract contemplates. Now, I think contracts are getting better. The first generation outsourcing we saw about 10 years ago, this wasn't done very well. Now it's getting done better, but again, there are a number of contracts we've seen that often this is not contemplated for. So you need to think about the scenarios. There's sort of two scenarios. It's termination, i.e. either where the customer or supplier terminates, or expiry, i.e. the contract comes to its natural expiry. So you need both those situations need to be contemplated. So you need an obligation on the service provider to do an exit plan. So this is about what assets will be transferred back, what happens to third-party contracts, what happens to IPR, what happens to data, what happens to personnel. So that's basically a transition either back to yourself as the customer or to a new service provider. And then there's the disengagement service. So these are the services effectively that allows the transition. So about migration, what happens to documentation, know-how transfer. Remember, when you're doing the outsourcing, you have lost a lot of that know-how. The service provider will have it, so you want to make sure you get the know-how from the service provider. What happens to data? Pricing. So this is often where customers get caught out. Often these disengagement services aren't priced for at the outset, and because it's the end of the contract, you're often held to ransom. You haven't got a lot of negotiating leverage, particularly because you haven't sort of appointed the service provider as the new sort of service provider. It's losing the contract. So you want to make sure when you're signing the contract, you know what the pricing is, or at least the pricing principles for the disengagement services. Otherwise, you'll be, as I said, you'll be sort of held to ransom by the service provider. In terms of management of staff, you also need to consider about 2P in terms of employment aspects. You need to make sure that, you know, service providers don't terminate or reallocate key staff. Sometimes service providers often take the A team out and put the B team or C team at the end of the contract, so they get 2P'd across to you. You want to make sure that doesn't happen. You want to make sure that they don't amend staff terms and conditions, because again of the 2P implications, and then non-solicitation, which is more a issue for the service provider, because they would want to make sure that you don't solicit any of their staff. Another thing which is often not contemplated for in sort of outsourcing contracts is in terms of exit management, so tendering for the new outsourcing. So often when you're doing tendering for the new outsourcing, the incumbent service provider often has a lot of data and information that you need to give to the bidders. Now, if you don't give that information to the bidders, you get into this concept of the post-contract verification period, where the new bidders or service provider says, we haven't got the information, so we need to see what it looks like. So what that means is when you, as part of the exit, or that you actually have an obligation on the existing service provider to give you all that data and information, which you can then pass on to the new bidders. There may well be obviously issues about confidentiality and commercially sensitive information, but you can address that by redacting or making sure that part isn't actually shared, but there'll be other things which should be able to be shared with the new bidders. Service levels during exit. Often service providers say, well, during exit management or disengagement, the service levels don't apply. I would resist this, particularly if you're paying for exit management and disengagement. The service levels should apply. It should be business as usual service levels. You may sort of agree a sort of reduced service levels, but you shouldn't be in the situation where there's no service levels during exit. And that's it for me. Exactly on time, I think, David.
Sam, thanks very much indeed. I'm just clicking things here to get myself on the screen again.
Yeah, sure.
Yeah, thanks very much. Look, that really was it. I said it would be a tour de force, and of course it was. And I think we now know why we need to have a few lawyers about. Yeah. As a project manager, we obviously rely on putting together a decent contract at the beginning, so that we don't left being high and dry when something goes wrong, if possible. Are there some key things that the project manager should be looking out for? I know you've gone through loads of stuff here, but where are the things that usually tend to go wrong, Sam?
Well, I think, as I said, the scope of the service and the service levels.
Yeah.
And that's probably one of the key areas. And then I guess governance and contract management, again, because it's not bespoke.
Yeah.
And then I guess the other thing is probably, you know, not knowing what protections you have in the contract. So, you know, that your client may spend a lot of money with us and other consultants, have a really good contract, a lot of protections, but then, you know, they get the contract and it's quite, as you know, these contracts can be long-winded. They actually don't know what protections they have and what remedies available. So what we usually recommend to our clients is, you know, have a user guide. It's not a substitute for the contract, but it's effectively, you know, a summary of the contract and basically an index, or it refers to various aspects of the contract in terms of service credits, liquidated damages. You know, if this scenario happens, look at this clause.
Right, and then at the bottom, it's got your phone number, yeah? Just
yeah,
in
of course,
case.
yeah.
Right. There's one other. I mean, I was interested on the 2P. I smiled slightly there on somebody moving the B team or the C team across. Now, nobody would surely do that, would they, Sam?
Yeah, we've seen that. Yeah. Yeah. I mean, yeah, the way to prevent that is basically have a contractual provision in the clause saying, you know, when you serve the notice to terminate, there can't be any reallocation of staff unless it can be justified by the service provider.
Yeah. Another one that I've got relates really to the project manager and his management team, because obviously the project manager is reporting into a board of some sort. And if the project manager can see a few areas of concern in this potential contract, and he may well struggle to get the the management team to take some of these things on board. Do you have any recommendations for the project manager there?
Yeah, I guess probably set out sort of, what it actually mean, what it would mean in practice, in terms of reality. If there is a problem, this is the actual practical, outcome or the result that will happen if you don't address it.
Yeah, well, one of the things I've done in the past,
Yeah.
Sam, is when I've taken on a new job, is to actually write down some of the things which I think are risks in that project, and therefore I've got something in writing at the end when it all goes a bit fluffy,
Yeah. The other thing no, exactly. The other thing we've seen is some project managers use us as a bit of a shield or a bit of an arrow, so to speak, in the sense that, they get our advice and then they present that to the board saying, look, we've got external legal advice and this is what the legal advice says. So the board's like, oh, okay, we better take that into consideration. It's a very brave board that ignores legal advice.
Yeah, it reminds me of the old saying, never get sacked for buying IBM, which is what they used to say years ago.
Yeah.
Just to be on the safe side, yeah.
Yeah.
Sam, I'm looking through the few comments here that people are making, and they're all very positive.
Yeah.
But they're not asking you to, go into any more of the detail. So I suspect you've covered so much ground that everyone's floored by and are now going desperately away to make sure their contracts have got all this in.
Yeah. Although Rob Gibbs has got a question. So Rob, do you want to?
Go on. I haven't seen this.
Right. Well, he says he's got a question, but he hasn't written it. So Rob, do you want to type away? I can't unmute. Can you unmute him, maybe?
I'm not sure I can, actually.
His question is about change control.
Right.
Mike has asked a question, can we have a copy of the slides?
Yeah, you can have a copy of the slides. We'll make those available to everybody. Yeah, we always do that with the presentations. And there's also the recording, of course, which we'll have, which we can make available to people. Yeah.
Okay, so Rob's question, how the supplier can be encouraged to take changes in a fair way. Yeah, it's an interesting one. I guess, one way to do that is effectively ensure that, they get adequately compensated. So they know that, for a particular change that there will be a certain additional revenue stream or, that they're getting paid for their efforts. If they have to effectively do it free of charge or effectively as a loss leader, it's going to be very difficult to encourage them to do those changes.
Yeah, I've seen this comment here also from Rob about taking a loss to start with, knowing that you're under the changes that you can overcharge.
Yeah, so I always advise clients effectively to say, look, service provider is in a business, there's no point screwing them effectively. They need to make a reasonable margin. So, if you think you're going to get one over the service provider by effectively having a really, a contract that is a loss leader, that's not going to be good for the relationship. So, completely agree with Rob. You may win in the short term, but effectively, you will lose out in the long term.
Right, let's read this other one out, shall I, from Rob? Are there mechanisms for ensuring that the changes are fully formed, well shaped before approaching the outsourcer? i.e., who does the business analysis, requirement spec, etc.?
Yes, so how we sort of usually do this in our contracts, we're acting for the customers effectively. It's part of the, the actual change proposal needs to usually come from the person making the change. That's the usual process, but you may want to sort of include a provision effectively give some consulting work for the actual service provider saying, look, we will pay you X amount for you helping us with this change proposal. But obviously you've got to pay for that, but that means that the change proposal might be, you know, a bit more robust. But obviously there's the issue about conflict of interest as well, because obviously, you know, if you're engaging them to do the change proposal, they'll do it in a way that's sort of factored in or benefits them. So, you know, I think, you know, either you need to make sure you do it properly yourself as a customer, or you get an independent third party to help with shaping that.
Yeah, good. There's a comment here from Colin Godbold.
Yeah.
Obviously, the good bit at the beginning, great presentation. Any thoughts on technology refreshment clauses? He says, I see a lot of long-running IT outsources where the client gets very unhappy about how hard it is to get the supplier to upgrade the hardware, software at a reasonable cost.
Yeah. So yeah, I've seen a lot of technology refresh clauses which are quite vague and imprecise. The way that you get certainty is actually built in more prescription and detail what you mean by that technology refresh. So, you know, X number of years that the hardware will be upgraded to, you know, the latest market standard, or the software will be upgraded. So you put in a lot of detail and prescription, and that technology refresh will be included as part of the charges. So it's not additional. So you will be paying for it as part of the charges, but at least you know you're not, you know, incurring additional costs at that point of technology refresh. But yeah, it's a difficult one, because, you know, often technology refresh clauses are very hard to sort of draft and negotiate, and that's why they're often very high level. But, you know, we usually spend, if we want to get it right, you spend a lot of time and effort in putting the detail in and getting those technology refresh. I wouldn't have it as a clause. I'll actually have it as a schedule, because it needs a lot of wording to actually get it into a form where it's enforceable.
Yeah, but presumably you can have a contract where you have these breakpoints where you can take on anything new that's happened and make sure that gets built in.
Yeah, you can, but as I said, that's an agreement to agree. So unless you've got the detail, you need the certainty for the detail. Otherwise, just an agreement to agree, and it's quite hard to enforce. So that's why it needs the detail.
Yeah, because in the IT sector, things do move ahead very quickly, don't they? So if you set up a long contract, there's a good chance that, you know, somebody else is going to jump on the bandwagon and leapfrog over, you know?
Yeah. Yeah. The other thing with technology refresh, it needs to be linked to benchmarking. Yeah. Because if you link the service levels to benchmarking and pricing to benchmarking, that's another way to get the technology because, you know, arguably the better technology means the costs are lower and the services are better.
Yeah. Right. Apart from more praise coming to you, I don't think there's anything else just at the moment. So shall we draw stumps while you're ahead, Sam?
Yeah, no, always like that. Yeah, no.
Well,